This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you for all of your support. Earlier today, I sat down with Sam Paredes. We did an exhaustive interview about what's going on in the California legislature right now, what are our options going forward, fighting them, and all those kind of things. In the process, we said a number of things that YouTube and Vimeo simply will not allow. They'll delete the video if I post it. If you're watching this right now, you're watching the censored version of the video where I've had to delete those things, and I think they are relatively important. They're probably very important for you to see. If you want to see the uncensored version of the video, then I'll see you over at Rumble. I will put a link in the description, and on YouTube, I'll put it in the first comment and pin it to the top. That's where you can see the uncensored version on Rumble. The censored version is what you're watching right now, and you can choose whichever one you like. All right, let's go to the interview. Now, I do have a clip from the California Assembly public safety meeting in which Dan Reed from the NRA and Sam Paredes, who's going to join me in a minute, from Gun Owners of California, testified. I urge you to watch the video all the way through. It's relatively short. It's about 2 minutes, but it's super important that you watch it because you're going to see the response of our California legislators, particularly one named Assemblyman Quirk. The name fits. So I want you to watch this all the way through because Sam and I are going to talk about this obnoxious response that we got to the fact that we actually have a constitutional right. Here's the clip.
You know, the Bruen decision set out a clear standard for the Second Amendment, how to view regulations. And what we're seeing this amendment is it's not improving California's concealed carry laws. It's in defiance of this court opinion. We're seeing a complete redrafting of places where law-abiding citizens can carry in the state of California. It's an incredibly confusing patchwork, and I think it's inconsistent with the test that was clearly laid out in Bruen, is looking at that historical context and whether there was a societal problem. And I just think that a lot of this is inconsistent. And we see where California, good cause is out the door, right? We recognize that. But you almost see this new language under a qualified individual is almost just we're having a shell game as to what it looks like. You know, the Supreme Court talked about an objective standard, and you're starting to put in subjective qualifiers, as you heard representatives from the DOJ talking about looking at publicly available statements and what does that look like for the First Amendment. We also see some other areas that may not be prohibiting categories that might disqualify someone from that. We heard about sensitive places, and the court stressed actually that not all places where people congregate or typically congregate are sensitive places. They referenced in the Heller case, they talked about schools and government buildings, and now we've seen this court look at legislatures and polling in courthouses. And so with this bill, you're now talking about parking lots outside restaurants, parking structures, extending it out to real property in the street, on the sidewalk. And so I think this is definitely in conflict with what's happening there. And I will try and secede the rest of my time over here to Mr. Paredes. But one other comment is there's not an opportunity for a non-California resident to get a CCW. And the court has ruled this is an inherent fundamental right. And right now, if you look at the language, it's limited to residents of the city, county, state. And so now you don't have an opportunity, and we don't have recognition or reciprocity with other states for someone to come here and exercise a constitutionally protected right. So with that, I'll turn it over to Mr. Paredes. Thank you.
How much time do I have, Mr. Chairman?
3.5 minutes.
Thank you.
Look at that, was perfectly square.
That's awesome. Mr. Chairman and members, Sam Paredes representing Gun Owners of California. The world is now different. The whole aspect of gun control and the Second Amendment has changed, and I think the state legislature is going to have to take that into account. I want to be perfectly clear that sometimes a half-truth is a big lie. Senator H.R. Richardson, in his book Confrontational Politics, said that he gave the example where a producer said, the New York Times said that my movie was colossal, when in fact the New York Times said that the movie was a colossal flop. So that was kind of a half-truth. Well, a half-truth is actually written in the amendments of this bill when it says that analogical reasoning under the Second Amendment is neither a regulatory straitjacket, and they put a period on that. That wasn't the end of the sentence. And a regulatory, nor a regulatory blank check. This bill is going along the lines of a blank check. It is creating all kinds of new provisions, all kinds of new restrictions that have no analog to the Second Amendment at the time of the founding. That is the standard. To justify regulation, the government may not simply posit that the regulation promotes important issues. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside of the Second Amendment unqualified command. Please understand that even Justice Kavanaugh said that states employ objective, they have to employ objective shall issue licensing regimes. Those shall issue regimes may require a licensed applicant to undergo fingerprinting, a background check, a mental health records check, training in firearm handling, and laws regarding the use of deadly force. He also said, going forward, therefore, the 43 states that employ objective shall issue licensing regimes for carrying handguns for self-defense may continue to do so. Likewise, the 6 states, including New York, California, potentially affected by today's decision may continue to require licenses for carrying handguns for self-defense so long as those states employ objective licensing requirements that those used by the 43 other states. No other state in the Union uses the standards and the laws and regulations and restrictions that are being proposed here, and to this extent. Of the 43 states that have shall issue, 26 of them, more than half of the Union, actually do not require any requirements for people to carry a concealed firearm in their own states. The reason they have a shall issue concealed carry weapons permit is to allow citizens to acquire one so that they can have reciprocity and carry in other states. It is clear that this bill does not rise to the level of being able to prove that there is a historical analog. And the court said that when you get, they warn judges that when you get these cases that are outliers, they're unconstitutional. I'm sure we will find ourselves in court. And as we predicted in Heller and McDonald, and in this case, we feel very confident that we will win and that this bill will never become law. Thank you for your time.
Thank you. Thank you. And I'll bring it back to committee members for any questions, or Mr. Quirk. Or...
Yes, I have a couple of comments. The first one is, Senator, I like your tie. Where to begin? We have a court of political hacks arranged by the Republican Party with a minority of votes because of the Senate being set up in the way it is. In Heller, they overturned over 100 years of jurisdiction, and if you look at the writings of Madison, it is clear that there's no private right to bear arms. It's a right for the militia. And that's a comment, not a question. Further, they're now limiting the rights to vote, as in, and you know, they ask for these cases so they can take liberty away from us, so they can take our ability to defend ourselves. I will never feel safe when there's someone with a gun in the room. Even a police officer who is trained makes mistakes. At any rate, in the abortion decision, the case was made that the Constitution doesn't mention abortion. Well, that's true. It also doesn't mention that the Supreme Court has the right to determine what the Constitution means. That was established early in our time, but it's simply precedent. That can be overturned too, and in fact, President Jackson refused to follow Supreme Court orders. I think The court is now seen as a political branch. I think it's time for the other political branch, the legislature and the executive, to simply say that the Supreme Court no longer decides what the Constitution is. It'll be decided by law. That's my comment. Thank you.
Thank you. Mr. Bryan, did you?
Well, yes. First, I cannot wait until my time in the legislature reaches the point where I can speak as freely as my colleague from the Bay Area.
Hey, I would have said that in my first term.
No. Now is the time for courage. Now is the time for action. If a piece of legislation like this is going to be taken to court, then take it to court. It definitely shouldn't die in this committee. So I want to thank the author for bringing it, and I motion to move the bill.
Sam, thank you very much for joining me. I'm super grateful for you. And after we get past our little hellos here, I do want you to respond to the clip that you just saw and the response from Assemblyman Quirk, because you do this all the time, put up with that nonsense pretty regularly. So there you go.
Well, Joel, first of all, it's always a pleasure to be with you. And people need to understand after watching this clip, this is what we face every time we go before the legislature. While we have been testifying, we have been called baby killers and murderers, and that we need to wash our mouth out with soap, that, we are warned constantly that it doesn't matter to them what the Constitution says or what the Supreme Court says. They're going to do whatever the heck they want to do because we're California. Even the chairman of the Public Safety Committee a couple of years ago, I believe I mentioned this to you, said that, regarding the Constitution, we don't really care about the Constitution. We're California. We do our own thing. And that's exactly what they're doing. Of course, Assemblyman Quirk does not criticize a Supreme Court when it's stacked with liberals. It only criticizes it when more conservative originalists who believe the Constitution means what it says to the letter are on that court, that he is advocating almost seditiously that we ignore the Supreme Court and go to the Congress for resolutions. Well, he may change his opinion on that based on what happens in the midterm elections, and his folks are driven out of power. But this is the attitude, the general attitude that pervades the more radical element of the Democratic Party, which is a majority of the members of the Democrat caucus, both in the Senate and the Assembly. They hate the Constitution. They hate the Second Amendment. They twist it to mean whatever they want it to mean based on their own proclivities and policy desires. So, welcome to the legislature. Senator Richardson always said that, hey, if you like sausage, don't watch the way they make it. And in this case, if you like legislation, don't watch the way the legislature makes it, because it is pretty horrific. And that is what we face every day.
Having worked in a meat packing plant as a kid, I can tell you're right about the sausage. Just so that you know. This is, I think, what the term gaslighting means, that I keep hearing bandied about a lot now. And that is that you have this Assembly member, Quirk, accusing the Supreme Court of doing something even though they're not, because previously the Supreme Court was doing that. The Supreme Court has now become a legislative or a legislative branch or whatever it was. I forgot.
Political entity.
A political entity, which of course is not the case with this current court, but it was the case with the court previously, where they legislated from the bench. What this current court is trying to do, and facing a lot of, well, frankly, danger, people protesting outside their homes. We had a guy wanting to assassinate a Supreme Court justice. They're not getting any protection really from the federal government by enforcing the laws. They're facing a lot of pressure, and yet they're still wanting to restore the laws to the Constitution. They're going back and saying, for example, with Roe v. Wade, look, this was never under the power of the courts to do. This was the power of the legislatures to do. And if we look at the Constitution, we see that we never had that power in this court, and so we're going to send it back to the legislatures because those are the representatives of the people. We don't live in a democracy. We live in a representative republic. We actually live in a constitutional representative republic, which means it's under the Constitution. The Constitution is the foundation. We have to follow that. And then we have representatives we elect to represent us and to write laws. We don't elect judges to write laws. And yet guys like Quirk are happy to have them legislate and create laws from the bench whenever they agree with them. But whenever they're trying to bring us back to the Constitution, well, all of a sudden they've become a political branch. No, they're not a political branch. That guy is gaslighting you. If anything, the Supreme Court right now is working overtime trying to restore the foundations of our country by bringing us back to the Constitution in every respect. There were a couple things that were mentioned in there. One, and I would love to have you, well, I'll tell you what, before I even ask you a question, what are they actually proposing in this SB 918 you were testifying about?
They are expanding the criteria for receiving a CCW in the state of California immensely. They are creating a patchwork of gun-free zones where even CCWs cannot carry, so much so that it is akin to what Justice Thomas was talking about in warning that the New York cannot make the entire island of Manhattan a sensitive place. They are including 1,000 feet from any school. 1,000 feet. You may not even know that you're within 1,000 feet, but you would be violating the law if you carried your CCW within 1,000 feet of any school. And in rural communities that are made up of one main street and there's a school on it, they basically are prohibited from traveling. Any transit property, vehicles, kiosks, anything on any public transit, you will not be able to carry. You will not be able to consume any alcohol. You will not be able to frequent any place that serves alcohol, serves intoxicated people. So now not only have you covered bars and wine tasting rooms, but now you've included hotels. If you've got gas station liquor stores that have a little restaurant inside and you can buy a beer to eat with your sandwich, or they have picnic tables outside. You cannot have your concealed firearm in places like this. They are raising the cost of receiving it. They are the Supreme Court said, as Dan Reed said, there has to be objective criteria. They are now changing what used to be the criteria for the issuing agencies to consider good moral character, and they've changed this to a qualified applicant. But they've added all kinds of subjective measures into that qualification that they think they're going to get away with under this ruling. They are all but requiring mental health evaluations, and you have to use the mental health expert that the issuing agency uses for its department, which means that now you're going to have tens of thousands of people lining up to get an appointment with this one or just a couple of medical professionals, thereby delaying the application process. They're going to be able to charge you $200 for that. They are raising the actual cost of receiving a concealed carry weapons permit. They are doubling the times required for the classes from 8 hours to 16 hours for a preliminary application, and from 4 hours to 8 hours for a renewal. They're requiring 1 hour of mental health training within the class that will allow you to receive a CCW. Of course, there's no definitions or criteria as to what any of this really truly means. It is a gross abuse of subjectivity in order to, and they've admitted, we want to make it more difficult and more cumbersome for people to get concealed weapons permits in the state of California. And we're going to throw everything against the wall to see what sticks. And the reason that I know that they have nefarious intent on doing this is because they put not one, but multiple severability clauses into the bill. That means that if any portion of this statute is declared unconstitutional, the rest will be allowed to stand as lawful and constitutional. So they know that a lot of the junk they've got in this bill is going to be declared unconstitutional, but they want to preserve whatever it is they can get away with. It's a heinous act, Joel. It tells you about the people that serve in the legislature.
Well, and it's honestly, I wish I could say it surprises me. It doesn't. This stuff, obviously, the vast majority of the things that you listed are not going to withstand a court challenge. Here's the question I get all the time. What's the process from here? Because if the state is allowed to continually do this and they know that it's going to have to go all the way to the Supreme Court again or all the way to the Ninth Circuit again, then they cause a continual delay in our rights by refusing to obey the law that is the law of the land, and just delay. Is there a process by which these things are, some judge says, okay, wait a minute, I'm going to put a stay on this being enforced until it's decided? Or are we just stuck for the next however many years going through these battles, never being able to exercise our constitutional rights?
When you talk to Chuck, he will be able to give you far more detailed response to that question. But they have also admitted that they know they can't ban, they know they can't do all kinds of stuff. So delaying, making things more expensive is something that they are admittedly using as a strategy to keep people from exercising their Second Amendment rights. And this is just the beginning. But I do believe that the courts will have an opportunity to summarily whack these guys on the side of the head and say, no, you're not getting away with this, and dismiss a lot of these cases, hopefully with prejudice, which means that they cannot bring it back up. We are in the driver's seat, although it's a long ride to paradise here. It's a long road that we're just going to have to stay steady, stay on, fight off every attempt that they throw at us. And the nice thing about it, Joel, you and I are both believers. When you know the end of the story, it makes it easy to go on the road, to travel the path. And we know the end of the story. They're going to be defeated in all of these measures. We are going to be successful in overturning many of the gun control laws that are in the books in the state of California. It's going to take us some time and effort. We are moving expeditiously. We are, for the first time in my memory, in a very long time at least, all of the various pro-gun actors who have a regular presence and a history of fighting for the Second Amendment in the state of California are in conversation to see what we can do to maximize our punch, to lay our swords down on the round table and discuss, okay, what are our priorities? What are you going to concentrate on? We're going to concentrate on this, and we support each other until we achieve the final victory, which will come. And that's a wonderful thing.
Yeah, truthfully, I've never seen that before. I mean, I've seen different people, everybody's going after their own thing. The idea that, I mean, even having the NRA guy there with you testifying and you guys kind of sharing that time, I thought was very effective.
Yeah, Dan Reed is a hero in California. He works for the National Rifle Association. He's the Western Regional Director for the Institute of Legislative Action. He is one of my closest colleagues in the fight to restore and defend and protect the Second Amendment in California. He's a young, articulate man with legal training. He's a lawyer, and we have been side by side in this fight. So if anybody wants to criticize the NRA, go right ahead, but you cannot criticize Dan Reed, because I will come to his defense with everything I've got. He is truly a hero in the state. There's a bunch of things first of all, I want to say I second that. We're not in a parliamentary procedure here, but I believe you're absolutely right. This is not a battle that they can win over the long haul. I think it's also important for gun owners to realize that just because the Supreme Court gave us an incredible victory does not mean that everything is fixed like that. It just doesn't work that way. What the NRA, or what the Supreme Court did essentially was take a toothless right, which had been rendered down to nothing but gums,
and put very sharp fangs back in it again, and then say, okay, here's how you use those. Go ye and do likewise.
Yeah.
And they sent the other cases they had down to the lower courts and said, hey, you know what? We just made a decision. You see these fangs, these teeth we just put in this? Redecide those cases with these teeth in mind.
Right.
And so I think what I see, and you tell me, what I see the legislature in California doing, and frankly in New York as well, is it's a delaying tactic, which you mentioned. I saw that coming. I think they are, you said it earlier, throwing stuff against the wall to see what sticks and what doesn't. I'm encouraged, and I will ask Chuck about that. I'm encouraged that there might be an opportunity for judges to dismiss these things with prejudice so that they can't keep bringing up the same stuff over and over again. But I wouldn't put it past them to bring up some new version of it and try to get around that, and I think they're going to do that. It seems to me that they're also posturing for their base, because some of these folks, like Assemblyman Quirk, he's from the Bay Area, where he's doing a lot of posturing so that he gets reelected if he's eligible to do that. They're also trying to get Gavin Newsom elected as president, so he does a lot of posturing for that. But I think they're also trying to burn up money, and they're not going to burn up their own money. They're trying to burn up the gun owners of California's money, CRPA's money, and so on, because they're coming out with, I mean, they've got like, what, 16, 18, 20 bills all of a sudden, boom, and that means we've got to go to court and fight every last one of those. Isn't that make it hard on organizations like yours to do this financially?
It makes it very difficult and challenging, but not overcomable, if that's a word. But yes, their intent with the strict liability bills that they're doing, they want to bankrupt firearms companies and gun owners and gun dealers, knowing that they don't have the depth of financial resources to be able to defend themselves in court all the time, even if they're going to win. Even when they win, the financial costs are such that many people will lose a business or lose a job because of that. But in every one of these cases, we are going to be asking for the losers to pay our court costs so that we can at least repay the funds that were expended by our legal firms, and so we can pay a lot of their legal fees. And unfortunately, that's coming out of taxpayer dollars. These people know full well that they're going to lose. They know full well that they're going to expend millions of dollars in defending a losing cause, and it's okay with them to spend those millions of dollars instead of spending it on the homeless problem or anything else, mental health, repairing the roads in the state of California like they should have done a long time ago. They're okay with taking money away from all of those important tasks and spending it to try to make a point on gun control and their personal beliefs. So we'll see what happens. And I think that in many cases we will be made whole after great effort and great cost. And frankly, it takes a long time to get through that process, oftentimes years to achieve victory. And the one of the most recent cases, it took 10 years to get where we were. The New York case took a long time, years and years to get to where it was. But we held the line. We were able to scramble whatever resources were necessary to support the lawsuit in amicus briefs that are not cheap. And we succeeded. And now we have the tools to be able to fight back, and we have the advantage, and we're going to use that advantage to the hilt.
Well, and I think now, because of that hard work, the process may move more, we may win more reliably and consistently, and we may win in some cases more quickly, because the courts now have a very defined test these things have to meet. The standard is quite high now to be able to pass gun control. In fact, quite high is probably the understatement of the century. So now it's a process of, it would seem to me, defending against this incredible overreaction by the states. I liken this, I've been a business owner for a long time. I've owned a number of businesses. I think the business we have now is my 6th business. And I've done a lot of negotiation as a result. And I liken this to the old inflatable clowns that you used to be able to get as a kid with the weighted bottom. You practiced your boxing with it. You bop it, pow, and it goes. oh, and then it comes back, hey, wait a minute, and so what happened is these states got bopped by the Supreme Court rather hard, and they went, wait, hey, hold on, and now they're coming back with this very over-the-top reaction. And what's going to happen, I think, is they're going to get hit in the face repeatedly, and after a while, they're going to be tired of getting hit in the face, and I think they're also going to run out of arguments sooner or later. You mentioned a couple of things. One was, I wanted to ask you about the sheriffs here in a minute, but you mentioned taxpayer dollars, and we talked about this kind of offline, and I will ask Chuck about it. But, at some point or other, I love the fact that Dan Reed brought up the reciprocity issue in that testimony. Because if you're an Arizona resident or a Nevada resident or resident of any state where it's a free state, and you leave your state and go to the next state, your constitutionally guaranteed right doesn't suddenly end at the state border, which it has up until now. But when the Supreme Court says that you have a right to bear arms in public, and they define that, then when you come to California, your right doesn't go away. So at some point or other, I can see these other states suing California because, for example, Arizona, suing California because California won't let Arizonans carry and robs Arizonans of their right when they're visiting. Is that actually a real thing, a possibility?
I think it's a very real possibility. The historical analog is that back when we had the colonies, people were never prevented from taking their arms to any state, any community, anywhere they went. As a matter of fact, I think I mentioned earlier that in some of the colonies, if you didn't bring your gun to church, you were fined 2 pounds of tobacco for not carrying your gun with you everywhere that you went. And nothing has changed. The historical analog is that we have a God-given right that is enumerated and protected in the Second Amendment of the Bill of Rights. And that right does not end at the border. You are absolutely correct. I'm sure that is going to be an issue that will come up in the future. Thankfully, we have a lot of lawsuits that are already in the pipeline, including the laws that the challenges that the Supreme Court granted certiorari, vacated the anti-gun rulings of the lower courts, and then remanded back to them, as you said, okay, folks, you have a new standard. Text as advised by the history and traditions at the time of the founding. That is the only guideline that you can use. Go forth and rule as under those conditions. So I think we're going to see a lot of these issues are going to be handled quicker, sooner than later, because we, in working with all of the amicus briefs on all of the lawsuits that we've been involved in, having to do with so-called assault weapons, large capacity magazines, waiting periods, you name it. All of these concealed carry, open carry, all of these cases are already in the pipeline. And this is going to supercharge them and require those courts to render a decision based on that criteria. And there's only one way they can rule. They are pretty much focused. Text, history, and tradition. If it happened at the founding era, you can consider it. But if it didn't, unconstitutional.
Yeah, we go back to 1791 and within a reasonable period before and after that, and that's it.
Yeah, yeah. So we're and the 14th Amendment, that which incorporated these fundamental rights to all citizens across the country, and that the states could not infringe on those rights. So, yeah, we're in the driver's seat. We just have to keep fighting. This is not the time to lay back and relax and say,
no,
we won it. No, this is the end of the beginning. Now we have to go forth and utilize the decision of the Supreme Court and Justice Thomas's ruling to recapture, as I like to say, restore the Second Amendment to its original greatness, its original meaning, and that's what we're going to do. And it takes money and effort and expertise to do that. And that's
well, and we'll get there, I think. Sam, you mentioned a word that is actually in the decision, and that is the word objective. That they can use objective criteria, but they cannot use subjective criteria. And I thought for me, I wanted to look up the word objective. because I know what it means, but you know how you know what something means, but you've never really read the definition. You just know what it means. So I thought I'd look it up, and this is according to the Oxford Languages Dictionary. Objective. This is the first definition. This is not 7 definitions down. Not influenced by personal feelings or opinions in considering representing facts. Now, I loved it when Assemblyman Clerk said, I'll never feel safe. You know what? That's not the standard. Whether you feel safe or not is not the test. Whether you are happy that people are going to be armed or not is not the test. The test is the history and tradition of our country and the plain meaning of the text as it was written and in 1791. That's the test. And it doesn't matter whether you feel good about it or not, or what your opinion is. I'll read the definition again. Objective, not influenced by personal feelings or opinions in considering and representing facts. That's as opposed to subjective, which takes all those opinions and feelings into consideration. Opinions and feelings about this do not matter. What matters is what the founders wrote and signed and put in the Bill of Rights in the Second Amendment. The right of the people to keep and bear arms shall not be infringed. Hold on, mic drop, pow, right? That's it. So I'm curious about. I just wanted to bring that up because I thought it was interesting. I'm curious about the sheriffs now, and again, this is just. I'm thinking. I'm getting ahead of us a lot. And I apologize. And then I want to ask you about these other bills in the legislature. What else? What other dirty tricks is the dirty trick squad up to? I was thinking about the poor sheriffs, and I say poor sheriffs because many of the sheriffs in California have been working overtime to try to figure out ways to be more shall issue with the restrictions of the way California law has been. Now, some sheriffs have been recalcitrant, not willing to do that, but more and more as time has gone by, more and more of our 58 sheriffs have been very willing to issue. So now comes the legislature and says, okay, we're going to pass this law and all these rules apply, but a sheriff is an elected official. And a sheriff, just like a police officer, takes an oath to uphold the Constitution. Now I think that sheriff bears some liability if they refuse to obey the SCOTUS ruling by following the unlawful decisions of the state legislature. So it kind of puts them in this sort of hot box. That's a weird place to be. And I know that letters have gone out to the sheriffs. Has anybody heard back from sheriffs as to what they're going to do or how they feel about this?
We have heard a resounding support for the SCOTUS ruling from many of the sheriffs in the state of California, the vast majority of whom we can characterize as constitutional sheriffs, those who obey and follow the Constitution. The Attorney General's office, the Department of Justice, sent out a notice to all of the sheriffs saying that the subjectivity of providing a cause or reason for wanting a CCW has been declared unconstitutional. But with a giant wink of the eye, the Attorney General says that we still have the standard for good moral character. That is a massively subjective thing. And he's encouraging them because that has not specifically been declared unconstitutional yet. But he's encouraging them to use that as any grounds that they need to deny concealed carry weapons permits. And he's basically talking to a lot of the chiefs and sheriffs in the greater LA basin, although we can now count the county of Los Angeles as not being a part of that, and the greater Bay Area. So I think that this has empowered a lot of sheriffs in the state. I've spoken to many of them, and they treasure the Constitution. They carry copies of the Constitution in their front pockets, and they treasure the oath that they took. And they will be one of our strongest tools in fighting the California legislature as it tries to force sheriffs to do things that are unconstitutional. Joel, they are our friends. They are our partners in this. So many of our sheriffs understand that they are the top elected official in their communities, and they have a responsibility to protect the rights of every lawful citizen in the community, and even the rights of criminals in the way they deal with them in order to exact justice or perform their duties. And they do an admirable job. So sheriffs, the vast majority of them in the state of California are friends. You will find some that will be recalcitrant to try to figure out any way they can to skirt around the Supreme Court ruling, but we'll get them too.
Yeah, well, they'll find themselves in court, but they're by far the minority of sheriffs in the state of California now. And just in case you're watching this and you're from another state, it's typically the sheriffs who issue these permits. It's not the state of California. So that's why sheriffs are so important. And it's also the sheriffs and the local police departments that are going to be tasked with enforcing these unconstitutional laws. And I suspect there are going to be some police chiefs and some mayors who don't want to have anything to do with that, because that puts their department and their city in the crosshairs of lawsuits as well. And they don't have a bottomless pit of money, particularly if you're a smaller city or a smaller town. It's interesting that you mentioned social media, and then I'd love for you, if you wouldn't mind, to kind of give us a breakdown as to what other cockamamie laws these people are coming up with. The idea of reviewing somebody's social media, we talked about the definition of objective. When you're looking at social media, you're just looking at people's opinions and the things that they've spoken about. Now, obviously, if you've got a terrorist and they're fomenting terrorism or something, but then how do you define terrorism? Is terrorism for example, perhaps in the mind of Assemblyman Quirk or whatever that dude's name is, maybe terrorism is simply the fact that you went out to the range and you bought a new rifle and you showed video of you shooting your rifle. Oh, well, you can't have a concealed carry permit. Or perhaps you showed video of the assemblyman making a fool out of himself in the Public Safety Committee, as he did, and commenting about that. Well, that's not an acceptable opinion. Well, this flies in the face of this other amendment called the First Amendment to the United States Constitution. So it's interesting to me that they are just attacking our freedoms in every conceivable way. They're leaving nothing out. I mean, with the red flag laws, that's illegal search and seizure. It's a violation of due process. There's the Fifth and Sixth Amendments right there, and the Fourth Amendment, Fourth, Fifth, and Sixth, really. And now they're going after the First in order to attack the Second. Anyway, what other crazy laws are they coming up with in Sacramento?
Well, we have one bill, SB 505, that is going to require all gun owners to obtain liability insurance for the privilege of owning guns. And that isn't just CCW holders, that's all gun owners. And whenever you have your guns with you, you're going to the range or you're going hunting, you have to have proof of insurance like you would when you drive an automobile. And they know full well, and we testified in committee pointing out that you cannot put demanding precursors on the exercising of a constitutional right. You cannot require reporters or YouTubers to pay for liability insurance because something that they say somebody might take umbrage to and do some terrible criminal act. You can't do it. You can't use a constitutional amendment to deny another constitutional amendment. And so it's folly on their part to try to challenge Second Amendment rights with requiring liability information. Oh, they also ignored the fact that there isn't an insurance company in the world that will insure the misuse of firearms or accidents. There really is legally no way that you can define an accident unless a gun was put on a table and somehow magically it went off. It's the unwise use of firearms that extend to what we call accidents. Those are not going to be covered by any insurance company. The theft, that's already covered under your homeowner's policy or your umbrella policy. But the misuse of a firearm, there isn't an insurance agency that will cover that kind of policy. We know that some of the Democrat staffers have been calling insurance companies throughout the state trying to find out if anybody would issue that kind of a policy, and they've basically said no. People can have, umbrella policies or homeowners policies that will protect the theft, but not the misuse of a firearm. So that's a requirement. They're doing more to expand the group of people that can request a gun violence restraining order, basically expanding it to almost anyone. And that's, as you mentioned earlier, that is the most insincere gun control policy that you can come up with, is gun violence restraining orders. You deny somebody their constitutional rights without them ever being able to meet their accuser, know who their accuser is, and defend themselves in court for a minimum of 30 days, in some cases longer. That is a violation of the Second Amendment, the 14th Amendment, the 4th, 5th, and 6th. They're continuing to do this. There's another bill that was signed by the governor over the weekend that prohibits any sort of firearms-related marketing to youth. Now, he made it sound like AR-15 manufacturers are using cartoons to advertise and market to toddlers and youngsters and stuff like that. In that one signature, he wiped out pretty much all youth camps, Boy Scout camps, if they have a shooting element in it, all of the camps that offer shooting, hunting, firearm safety, they're all wiped out with the stroke of a pen. That had an urgency clause to it. So as of right now, that's the law of the land. It wiped out any sort of advertising to any of our aspiring shooters, young shooters who are either training to acquire a scholarship to go to a major university to be on a shooting team, any aspiring shooters who are looking to become Olympic class shooters. They are all affected by this law and the marketing to them for the types of firearms that they might need in order to accomplish their goals in life. All illegal under California state law. So Joel, you name it. They've got more gobbledygook being sponsored in the legislature. They're banning gun shows in Ventura. They're banning gun shows in Orange County. They're banning gun shows across the state. Those are three separate bills. They're banning the sale or even the possession of precursor parts, 80% lowers or anything that could eventually become a firearm after somebody manipulates the products that they buy. They're like I said, they're throwing the mud against the wall, and it's not really mud, to see what sticks. And it's crazy. The governor will have an opportunity to sign, including the two that he's already signed, up to 16 gun control laws that will be sent to his desk before the end of August. So it's
and he'll sign them all. However wacky they are, he's going to sign every last one of them. I don't think there's any question about that.
All of those people who have sacrificed, especially with the ultimate sacrifice, for us to live in this country with freedom and liberty, as designed by our founding fathers in the founding documents, the Declaration of Independence, and the Constitution, including the Bill of Rights, has to be honored. That is our legacy for the future. You know what? If you don't like it, you can't change the Declaration of Independence. But if you don't like it, you can try to change the Constitution of the United States. We'll fight you every step of the way, and you will not win. But there is a process that our founding fathers established to give you an opportunity, those who do not like the Second Amendment, who do not like the Constitution, who do not love this country, and who do not appreciate the sacrifice that millions of men and women have made in defense of this country so that we and our posterity can live in freedom and liberty. I'm sorry, but there are still some of us here who are willing to fight for that. Yeah, maybe we might not be in foreign and exotic lands, fighting to protect our way of life, but we are here on the ground in this country, willing to give up everything that we have, our treasures, our honor, our sacred honor, in order to preserve this greatest experiment in history and liberty since the creation and foundations of the earth, save the Garden of Eden. And that's what we're going to do, because we know that we save lives with everything that we do. We protect freedom, we protect liberty, and we want to give that to our children and our grandchildren and those of our family members to come. So Joel, taking an oath is a sacred thing, and either you are serious about it or you're not. And I hope that all of those people who are put in harm's way with difficult decisions that they have to make, that they believe that honor is sacred, and that they are going to defend and protect the Constitution of the United States, and that includes the Bill of Rights and the Second Amendment. So thank you.
I would have the same conversation with mayors and city council members. You guys took an oath. You need to obey it. Look, Sam doesn't have to stay in California. I'm aware of the fact that Sam could sell his home like any of us because prices are insane, and he could go to another state, buy a beautiful place for a pittance by comparison, and move. Rick Travis could do the same. Chuck Michelle could most certainly do the same. I could do the same. I don't do this for a living. I could sell the rental property, sell my house. We could pack up. We already own property in Arizona. We'd be gone. Okay, we're here because I was telling somebody the other day, I'm not doing this for me. Sam and I are only a couple of years apart in age. I'm not doing this for me. I'm doing this for my children, and as a grandfather, for my grandchildren, and for their children's children's children. We've got to preserve the Constitution. If we don't preserve the Constitution, then those who come after us are not going to have a very bright future. So this is a fight that has a lot of meaning to it. And yes, it's a fight in the courts, and it's a fight in the legislatures, and it's a fight in legal battles with the local community or whatever, leaders, whatever you want to call them. It's a fight at the ballot box. By the way, I encourage you, please do vote. If you think your vote in California means nothing, I want you to look at the fact that San Francisco, one of the most liberal places on the planet and probably the most liberal city in the country, just gave their whack job liberal Soros-backed DA the boot. And they did it at the ballot box. They're going to do the same thing in Los Angeles and get rid of that joker up there. That's the ballot box at work. The ballot box works. It isn't easy, but it works. So I urge you to vote in California. I urge you, I know money is tight. We're in the middle of stagflation. If you don't know what that is, look it up. We're in the middle of stagflation. It's tough on everybody. It's tough on me. It's tough on Sam. I own a business, right? I mean, that's how I make my living. It's tough on us. Look, if you have the ability to contribute to CRPA or Gun Owners of California, I urge you to do that, because this fight is going to take a while, and it's going to cost money. And there are very good people who are not making a fortune. They're doing this because they love this country, and they love the Constitution, and they want to preserve it. Contribute, please. If you can contribute enough, $5, contribute $5. If you can contribute $50, contribute $50. If you're an extraordinarily wealthy person and you can contribute a lot more, then contribute a lot more. If you're a billionaire, write a check for $1 million and contribute it, because it's lunch money to you, and everybody knows that.
Yeah.
Okay? So if you have whatever your ability is, we're now in a place where the Second Amendment has teeth that it hasn't had for 100 years. Now we can win. It's going to be a dogfight, okay? And it's going to be bloody, not literally, but I mean, hopefully. But it's going to be tough, and it's going to be painful. But we can win. So I urge you, please do contribute. Please do help. Don't contribute to me. I do appreciate the support on GunGuyTV crew, but don't send me extra money. Send it to Gun Owners of California, for crying out loud. Send it to California Rifle and Pistol Association. They can put it toward the lawsuits, the amicus briefs. They got to pay for plane rides back and forth to Sacramento all the time. I mean, it's very expensive to do what they're doing, and they need all the finances they can get. And those are the two organizations that are fighting the hardest for you. I'll put a link in the description, so I urge you to support them. Is there anything else we haven't talked about, Sam, that's going on? That other than the fact that, thank God, those lunatics, and not all of them, by the way, in the Sacramento are lunatics. We actually do have some good assembly members and some good senators, but they're just few and outnumbered. But the lunatics, at least, are gone on vacation or whatever.
Mm-hmm.
What can we do in the meantime to prepare for the coming fight and to help with the fight that's going on?
Number one, the truth is extremely powerful. Stay armed and informed with the information that you need to be able to spread the word to your friends, your family members, your co-workers. Let them know the truth. We provide details as to what the truth is. We provide copies of the Supreme Court ruling and what that means. We provide commentary. Arm yourself with that information so that you can spread the word. Sending us resources, greatly appreciated. We cannot do what we do without your help at Gun Owners of California. We try to be the tip of the spear in fighting for your Second Amendment rights right here in the Golden State. But it is equally important for you to spread the word. Share it with other people. If you have friends on any of the social media networks, let them know how you feel and what you know about the Second Amendment rights, and keep that conversation going. Yeah, there'll always be knuckleheads out there who are going to call you all manner of things, but there were knuckleheads at the founding who thought our founding fathers were brainless and boneheads for fighting against the most powerful country in the world in order to achieve freedom and liberty. Ultimately, when they were successful, everybody jumped on board and say, hey, you know what? Freedom feels pretty darn good. And for a long, long time, freedom and liberty were at the forefront of everybody's mind at the founding. But our founding fathers, in their wisdom, some of them said, you know what? In future generations, there are going to be people who forgot about the sacrifices that were made. They forgot about the shedding of blood that it took to achieve freedom and liberty, to create this country. So we are going to enshrine the most important God-given rights that we have in the Bill of Rights and amend that into the Constitution. Some of our founding fathers said, you don't need to do that because everybody knows what it took to fight for freedom. Well, thankfully, some of them said, yeah, but your great, 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 great grandchildren will not know the experience that you went through. So we are going to enshrine these constitutional God-given rights in the Bill of Rights, and they added that, and that's what we are fighting for. These rights that nobody can take them away, even if they wiped it out, even if they wiped out the Bill of Rights. God gave us the right to protect ourselves, and we are going to continue to fight for that right. So, Joel, thank you for spreading the word. Thank you for sharing it with people all over the country. We appreciate you immensely, and we will continue to work forward. And I will come back with you to you when we have more information on what's going on. Oh, by the way, I want to let people know that based on the data leak from the Department of Justice, now, mind you, be honest when you refer to this. The media and the Attorney General's office have been calling it a breach. A breach is when a bad actor breaks into a system and extracts information. This was not a breach. This was a leak of information. We are working on a potential class action lawsuit, and anybody who believes that their data has been given away, and that includes their name, their address, their date of birth, their gender, and their driver's license number, is now a part of the internet forever. If you believe that your information was given away because over the last 10 years you applied for a concealed carry weapons permit, whether it was granted or denied, whether you have purchased or sold a gun in the state of California and had to go through the dealer record of sales, commonly known as the DROS system, if you have applied for or are a participant in a gun violence restraining order, if you have a California firearms safety certificate, which is the test that allows you the permission to purchase a gun in the state of California, if you are on any of those lists, we invite you to send your name, your county of residence, and your email addresses to this email address. Help desk, simple plain English, help desk at michellelawyers.com, MichellLawyers.com. We are collecting this information. Our attorneys are spending sleepless nights going over all of the state and federal laws to see what the potential is for a class action suit, and we're trying to get ahead of that curve. So if you feel you were affected, please submit your information, and we will, in return, we will keep you informed with updates as to what's going on this case and on the issue in general. And we don't need any more, we don't want any more information other than your name, your county of residence, and your email address, because unlike the other side, we will not share that information or allow that information to be shared with anyone else except for this effort. So, Joel, God bless you. Let's keep fighting. We're going to get together again, and I look forward to that time.
You betcha. Thank you so very much, Sam. I appreciate it. Have a great week.
You too.
Thank you very much for watching the interview all the way through. I realize these interviews are long, but honestly, we've got to get the information to you as quickly and efficiently as possible. I do want to leave you on an upbeat note, if I may. And I'm going to quote Larry Kudlow, of all people, who's one of my favorite business commentators. I do own a business. Larry is fond of saying the cavalry is coming. So I want to just share with you that not only is the cavalry coming, it's here. The cavalry is here, and the cavalry is fighting, and the battle has been joined. Keep in mind, though, that just like any other cavalry, like any other force that's fighting for you, they need supplies. They need a supply chain, okay? You and I are their supply chain. Now, honestly, I think I'm part of the cavalry in the sense that I'm the guy that's the war correspondent letting you know what the cavalry is doing. But nevertheless, the cavalry does need your support. It needs funds. It needs the capability to fight for you. So don't sit back on your laurels and rest and say, okay, the cavalry is here and they're fighting the battle for me. That's true, but as Sam said, get on social media, share this video, share this interview, share these things with other people, share them on your social media accounts wherever they are. Make sure that if you're in California, you go apply for a concealed carry permit. Be unafraid. Go submit your application and get yourself in that line. If they're trying to scare you from doing it, that's what the whole idea of the leak of data was about. Don't let them put you in a box and frighten you from that. Be involved. Get in there and apply for your permit. Go to the range, invite somebody else to the range, do all the things you would normally do as an honest, hardworking American and a Californian, and make sure that you're also supporting these organizations. I will put a link in the description to Gun Owners of California and the CRPA so that you can contribute if you'd like to do that, and I urge you to do that, whatever the amount. And obviously, if you have a lot of money, please contribute more, that we desperately need it. I'll also put the email address, helpdesk@michellelawyers.com in there. So if you feel like you have been doxxed by this release, please do send that information that Sam requested. I would deeply appreciate that. Have a wonderful week. Chuck Michel's coming on the show in a couple of days, and he'll give us more legal stuff from the lawyer's point of view, and then we'll have Sam back and Rick back and some other people to talk about this as things develop. So stay tuned. Have a great week. Thank you very much for all of your support, and wherever you go, whatever you do, stay safe.